Good morning. I'm Christine Axsmith, a consumer and foreclosure attorney. My clients include district residents who were lured into loans whose terms were misrepresented or whose houses were taken from them with forged affidavits. You will recall just a few years ago, we had a problem in this city with foreclosures and robo-signing. Robo-signing is when false affidavits were forged and used to throw people out of their homes in foreclosure. So in response, this body passed the necessary legislation to halt this practice in the district by passing the Saving D.C. Homes from Foreclosure Act. The intent was to clean up the foreclosure process. The spirit of this law is being circumvented because the courts lack the needed clarity about the rules of foreclosure. You need to provide it so the Saving D.C. Homes law is properly interpreted. One problem is that the law has not been fully implemented. There is a loophole in the system that mortgage companies are exploiting. By filing lawsuits in D.C. Superior Court, mortgage companies are avoiding the requirement for a mediation certificate as set forth in the Saving D.C. Homes law. Another problem is a lot of people don't have the money for full-scale litigation and discovery required to demonstrate that these affidavits are fraudulent in the context of a civil lawsuit. I want to talk about ways to stop this. D.C. constituents are entitled to, and I therefore propose, that a mediation certificate be required for all foreclosure actions, whether by non-judicial procedure or by lawsuit. It would set up the same standard for both avenues of foreclosure. And why is this good for D.C.? Each foreclosure costs the city $19,229 in safety inspections, police activity, fire response, and trash removal. Estimates are that violent crime rises 2.33% for every 1% rise in foreclosure. That doesn't include the costs of judicial administration. The Saving D.C. Homes Act set a standard for the use of documents when foreclosing in D.C., requiring the results of the loss mitigation analysis to be presented and reviewed, a true copy of the mortgage, every assignment of a mortgage, and proof of standing to foreclose. Only after this high standard of integrity is met will a mediation certificate be granted and permitting the foreclosure to go forward. The reality is the courts are not requiring a mediation certificate because it's handled like a regular lawsuit. This creates two separate standards and two separate processes for pursuing a foreclosure in D.C. Therefore, the Saving D.C. Homes Act has never fully been implemented. The mortgage companies think they can just file a lawsuit to avoid getting a mediation certificate, and so far, they are right. It's like a corporate veto of the law this council worked so hard to write to protect D.C. residents. I ask this committee to take action on this matter by requiring all foreclosures to be granted a mediation certificate. If there are any additional questions, my contact information is included in the written record. Thank you.
Thank you very much.